I'm going to talk about disclosure. Disclosure can be split into two distinct elements. At the police station, disclosure means the information provided by the police to a solicitor prior to interview under caution. But disclosure can also mean, once a matter has gone to court, the information provided by the prosecution ahead of any trial. So it can mean two distinct matters. I want to talk about the disclosure at the police station stage. So this is the information that will be provided to a solicitor at the police station by an interviewing officer prior to the interview itself. When a suspect is taken into custody, one of the reasons given for the arrest and for detention is to secure and preserve evidence. Some of the evidence is fairly straightforward. It could, for example, be fingerprints, it could be DNA, it could be footprints, it could be clothing. But the evidence could also include the interview under caution and what is put to a suspect in interview under caution and what, if anything, a suspect says during interview under caution. So when a suspect is detained and when that detention is authorised, part of the detention is to secure and preserve evidence. And that evidence is the interview under caution. So when an individual is to be interviewed by the police, provided they have a solicitor present, the solicitor will meet with the investigating officer beforehand, and the investigating officer will normally tell the solicitor some, not necessarily all, of the evidence that the police are currently in possession of. The police are not obliged to tell the solicitor everything, and it might be that the police want to withhold some crucial information in order to see whether the suspect contradicts themselves in interview or muddles themselves up when that further disclosure, that further evidence is given later on. So an example would be a suspect arrested on suspicion of burglary. The police may tell the solicitor that the suspect has been found near to the scene, or that the suspect has been identified by somebody who was walking by at the time, but the police officer might, for example, also have information related to fingerprints or footprints that are found in the property, and might not necessarily tell the solicitor at that stage to see what the suspect then says in interview under caution. So with disclosure, it's important to establish the extent to which the police are prepared to say what they know, or whether they are going to hold any information back. And it's one of the questions that a solicitor can ask an officer beforehand at the disclosure stage, whether that's all the disclosure that has been given or not. The disclosure can be recorded, it can be written down. Police forces sometimes visually or audio record the disclosure given to the solicitor prior to interview under caution. If the disclosure is simply given in writing, for example, it might be advantageous at the start of the interview under caution actually to set out in writing and during the interview under caution exactly what has been given by disclosure to date by the officer prior to the start of the interview. And the reason for that is that if the matter then goes to court and there is a question, for example, maybe of an adverse inference, whether or not the suspect answered questions, whether they should have provided the information that they're now giving in court, it might be that one of the explanations they might wish to put to a court to avoid the adverse inference is lack of disclosure given by the police at the disclosure stage prior to the start of the interview under caution. So with disclosure at the police station, the police don't have to give everything. It's advantageous at the start of the interview to clarify what the disclosure given to the solicitor actually is. And it's also advantageous to ask the officer to confirm whether or not they are withholding any of the disclosure prior to the start of the interview under caution.